Yuga Labs wins trademarking ruling. Surprisingly, even though I am a dumb comedian, I do happen to play a trademark research expert on TV. I may have actually even written a book or two about that, so I can give you some non-legal information, but I do know quite a bit about trademarks.
Did you write a book, though?
I did.
Oh.
I did.
Oh, never mind.
No, I really did. Yeah. If you go on Amazon right now, do-it-yourself trademark under my nom de plume. Here's the summary of what happened, yesterday. Yuga Labs owns the unregistered BAYC marks, which are valid and enforceable.
Bo, they didn't even have a trademark. How can this be?
Well, that's because trademarks are not what you think, not like a patent, okay? So trademark is, when you think of getting a trademark, it's really just getting a registration of trademark. The trademark, you own a trademark just by using it across state lines. Now, you have to prove it, and the more you use it, and having the trademark itself is really good to have. But technically, just like a copyright, the minute you create it, you own it. And then as far as trademark rights, you get federal trademark rights the minute you are doing commerce, interstate commerce, they call it. So the second thing of the ruling was NFTs are goods for the purposes of the Lanham Act. Now, this is super important because it gives NFTs the same trademark protection as any other good or service.
Like pickles? Like pickles have trademark protection.
Well, no, not actually. The word pickles, that is a descriptive phrase. And if you started pickles, you could not register that. Now, Vlasic pickles is a trademark.
Diapers?
A specific kind.
Diapers, what about them?
Depends.
Depends on what?
No, it depends. Diapers is a trademark, but not diapers.
Diapers. Never heard of that brand.
All right, anyway, Lanham has 4 parts: trademark infringement, trademark dilution, unfair competition, and false advertising. Those are the parts, that protection that you get, And that's now been decided for NFTs, which is super cool. One important concept that comes out of this is what's called likelihood of confusion to the general public and the popularity of the mark. Shockingly, I know you may find this crazy, but the mark itself, it matters how popular. And it is. And here's why. So if you called your Bored Apes not very aware apes, you could still get sued. Because that is very confusing. You're going to think that's probably Bored Apes, or Snored Apes, or, or you're going to call your shoe company Snikey, That's
what about like floorboard apes?
Yeah, depends, right?
It does depend.
There you go. So if you create Nike anything, forget it. You're getting sued. I don't care if you make Nike ice cream and you think that no one would ever think that Nike's so famous that they would have a very good cause to sue you. It just matters whose lawyer can beat up whose lawyer. It really does. Because the idea is no trademark police are going to come and tell you stop using Depends diapers if you name your diaper company Depends. No, what there is a big fat lawsuit from Depends against you. And as we see today with this Yuga Labs lawsuit. So if you did like Millennium Software and then you made Millennium Ice Cream, that's fine. There actually is a Millennium Ice Cream, I think. But the point is those two can coexist because they're not as famous and you probably assume they're different things. Probably can coexist. But you still could sue them and say, I think you're wrong, and win. You never know. I'm going to sue you. And you go, geez, I got no money. I'm scared. I'm going to change it. And that's pretty much, and that is trademark law.
That would open up a restaurant called Pampers.
Would you? And would you pamper people?
Yeah.
Okay.
Could the diaper company sue me?
That's a good question. Probably not.
Probably not.
No, because you would not think of food when you get a diaper. You know?
Well, I mean, some people probably do.
Dogs might. Okay, anyway. So Ryder Ripps,
Becophiliacs or something.
His defense was that this is free speech and all those things were thrown out. Some people will invariably bring up, what about Andy Warhol? How come he got to do it? Well, number one, Andy Warhol did wind up having issues to some degree with Campbell's Soup. However, Campbell's Soup decided, hey, this is a lot of great publicity, so we're not going to bother suing him. Whether he'd win or not isn't the point. He'd have had Campbell's Soup up his butt. Okay. Then to make it even sillier,
I had that happen once before.
Yeah, me
it's
too.
Not good.
Yeah, it's bad.
It's not a good, man. The tomato soup. Ugh.
Yeah,
just stings.
It's terrible. But believe it or not, Campbell's Soup actually hired Warhol after he did his initial ones and had him do a Campbell's Soup thing for one of the CEOs of the company when he was leaving. You can't make something and then try to utilize some sort of gimmickry to sell something very similar. Okay, you can always wind up being sued for that, and it's up in the air as to what happened. Hey everyone, I'm Bo Blaze.
And I'm Chris Park.
And this is the NFT Comedy Hour. Kinda like The Daily Show, but with NFTs and stuff. Don't forget, we also do the show Comedians Talk to NFT Stars, where we talk to some of the most interesting people in the NFT world. That show is also available as a podcast and as an NFT. Visit blazo.art/links. blazo.art/links.